Hello, my name is David Winch and I'm a forensic accountant with Bartfield's Forensic Accountants. And today in this webinar, we're going to be talking about a problem that has occurred a few times over the last 2 or 3 years, particularly in relation to confiscation by local authorities following a conviction for breach of enforcement notice in particular. So it's the problem of confiscation and a summons referring to just one day. So let's get cracking with the agenda. First question, what's the problem? I shall explain that a little and then talk about a decision in 2019. And I must apologize in advance to all the defendants that I'm going to mention today, because I'm probably going to pronounce every defendant's name incorrectly. But I'm going to say this was a decision in 2019 in the case of Panayi. And then Panayi was distinguished in 2020 in the case of Roth. Then there was another case in 2021, just last month actually, the case of Kamyab, in which there was further discussion of those two earlier cases, and we get to where matters now stand, where we have a summons that refers to just one day in relation to a continuing offence. And finally, we shall wrap up with how Bartfield's Forensic Accountants can help you. Okay, let's kick off. So what is the problem? Well, the prosecution might, in some circumstances, find it convenient when drafting a summons for a continuing offence, and this is the issue. It's a continuing offence to refer in the summons to just one day. And we'll see an example of that in Panayi. That may avoid the need to go into a protracted history of events. And again, we will see when we come to look at the case how that happened. And we will look at the wording of the summons in the Panayi case. The reference is there if you want to look up the actual judgment. Okay, so let's look at the summons and the actual wording of the summons around which the whole case revolved in confiscation. On or about 18th of February 2016, you, being the owner of 282 to 284 Caledonian Road, London, N1 1BA, breached an enforcement notice issued by the London Borough of Islington on 22nd of August 2003. As you see, a long time previously. In respect of unauthorised developments at 282 to 284 Caledonian Road, by failing to comply with the remedial action required in Schedule 4 of the enforcement notice, contrary to Section 179, subsections 1 and 2 of the Town and Country Planning Act 1990. That was the actual wording of the summons in Panayi's case, and that is what the whole case revolved around at confiscation. But let's look at the factual history here. On 22nd of August 2003, an enforcement notice was issued with regard to a property extension that had been built at the property, which was not in accordance with the planning permission that had been given for an extension. It went literally above and beyond what had been authorised and resulted in the local authority issuing an enforcement notice. The property owner appealed against the enforcement notice, and that appeal was dismissed. But because that process takes some time, the owner was given 1 year from the date of dismissal of the enforcement notice to comply. So he was given until the 12th of February 2005 to comply with the enforcement notice, which had been issued in August 2003. On the 2nd of November 2006, he hadn't complied, and the council wrote to him and asked for an explanation. And there was then some toing and froing. And the upshot of all of that was that on the 28th of March 2007, the council wrote to the owner to confirm, this is quoting, to confirm the council will not at this time be prosecuting for the non-compliance. However, the enforcement notice was not actually withdrawn, but the council did say, we're not going to prosecute for this non-compliance. And you can imagine the effect of that was that the owner didn't comply. Years went by, and in 2014, the owner actually applied for a certificate of lawful use. In other words, to regularize what had actually happened. On the 18th of February 2016, the council refused the application for a certificate of lawful use. And we will see this date of 18th of February 2016, of course, in the summons. 28th of June 2016, the council issued the summons commencing prosecution, and that summons, as we've seen, refers to on or about the 18th of February 2016. 26th of September 2016, Mr. Panayi was convicted in the Magistrates' Court and committed to the Crown Court for sentence and confiscation. 15th of January 2018, he was fined in the Crown Court. He was fined £25,000, and a confiscation order was made for £95,920 in the Crown Court. Of course, that £95,920 was in addition to the £25,000 fine. Now, you might be asking, how did the court come up with a figure of £95,920? Well, the prosecution had asserted that the defendant's benefit of his particular criminal conduct was £243,817.98. And they based that on rental income over the period from the 12th of February 2005. Now, if you remember, the 12th of February 2005 was the date when the owner was supposed to comply with the enforcement notice, having lost his appeal against the enforcement notice. If you remember, the enforcement notice issued in 2003, he appealed. In 2004, the appeal was dismissed, and he was then given 12 months from the dismissal of the appeal to comply. So he was expected to comply by 12th of February 2005. So this figure of 243,000 based on rental income from that date from which he was expected to comply up to September 2016, which was the date of his conviction. And the local authority had uplifted that benefit for changes in the value of money. They didn't assert that there was any other benefit, and they didn't, in effect, pursue an assertion that he had a criminal lifestyle. Now, you might find that a little surprising because, let's face it, what they're saying is that he has been engaged in a criminal offence for a period of at least 6 months, in fact, for a period of over 10 years, from which he's obtained a benefit of at least £5,000. So they're actually well within, on that basis, the parameters of a criminal lifestyle. And in fact, this particular gentleman had been involved in other breaches of enforcement notices over the years. He wasn't a stranger to this type of proceedings. So you might have thought that they would have gone for a criminal lifestyle and a much larger figure of benefit. Anyway, they didn't. The benefit alleged by the prosecution was limited to the rental income on this property over that period from February 2005 to September 2016. The Crown Court didn't accept that benefit figure, they found the benefit to be £95,920, and that was actually based on 50% of the rental income with no uplift for changes in the value of money. And for the rental income after March 2007, because the Crown Court took the view that, as the council had written to him in March 2007 saying, we're not going to prosecute, that in confiscation, they were not going to look for benefit prior to that March 2007 date. Incidentally, one of the issues that sometimes comes up in confiscation proceedings is that there is a mistaken understanding that prosecutions sometimes have, that they are limited to 6 years in terms of computing the benefit for confiscation. And that's to do with the relevant day and the criminal lifestyle assumptions. Actually, the position is that as far as particular benefit is concerned, it covers the period of the offence. And in this case, the period of the offence was a lot more than 6 years. And in terms of assumed benefit, then the assumptions only apply on after the relevant day. And the relevant day is usually 6 years prior to the date of charge. There are exceptions to that, but that's generally when the relevant day is. But of course, somebody's general criminal conduct is all his criminal conduct. So if somebody has been convicted of offences long in the past from which there is a benefit which can be computed, then that falls into their general criminal conduct as well, even if it's not the particular benefit and even if it's prior to the relevant day. But anyway, in this particular case, coming back to this particular case, the Crown Court said we're taking 50% of the rent received from March 2007 onwards, and we're not making any adjustment for changes in the value of money. Okay, so what happened then? Well, Mr. Panayi appealed to the Court of Appeal. And in February 2019, the Court of Appeal held that the conviction related to a single day, which was a day on or about the 18th of February 2016. But whether it was the 18th of February itself or a day around about that time, it was a single day. The Court of Appeal said that's what the summons was, that was what the conviction was, although they said it's accepted, if you like, it's accepted by everybody, that the defendant had acted unlawfully from 2005 onwards by failing to comply with the enforcement notice. And the Court of Appeal held that there is, as they put it, nothing which entitles a court to extend the meaning of particular criminal conduct beyond the conduct of which a defendant has been convicted or pleaded guilty. So they said the benefit is limited to the rent obtained on a single day, which was £58, and so they amended the confiscation order to make the benefit just £58. Of course, on that basis as well, Mr. Panayi didn't have a criminal lifestyle because he hadn't been involved on that approach. He hadn't been involved in an offence committed over a period of at least 6 months. He'd been involved in an offence committed on a single day, and he hadn't had a benefit of at least £5,000. He'd had a benefit of £58. So happy days for him. And let's just look again at the summons as to why they came to that conclusion. So the summons said, on or about 18th of February 2016, you, being the owner of the property, breached an enforcement notice issued by the London Borough of Islington on 22nd of August 2003 in respect to the property by failing to comply with the action required, contrary to section 179 of the Town and Country Planning Act. Notice that in that summons, we know, don't we, because we've looked at the facts now, we know that he was required to comply with that by a date in 2005. But there's no mention of that in the summons. The only dates in the summons are the on or about the 18th of February 2016 and the date the enforcement notice was issued, which was not the date by which he was required to comply with it. So that is how that case ended. And of course, lots of people who have been subject to enforcement notices, subject to confiscation in some chunky figures very often, were looking at this and thinking, hey, we should only be dealing with 1 day's rent. So things moved on. In July 2020, there was a case of London Borough of Haringey and Roth, and the reference is there on the screen. And Panayi was distinguished in the case of Roth because in Roth, the summons did indicate a date on which non-compliance began, whereas, of course, the summons in Panayi hadn't. So let's look at the summons in Roth's case. Well, this is what it said. On 18th of May 2017 at 39 Vartree Road, London N15 6PR, you did fail to comply with the requirements of an enforcement notice served on you as the owner of the property by the London Borough of Haringey, which, and crucially, which required you to cease using the property as self-contained flats by 9th of March 2013, contrary to section 179 subsection 2 of the Town and Country Planning Act. So in this particular case, the summons in Roth's case actually did give the date when he was required to cease using the property as self-contained flats. And so the Court of Appeal in Roth's case said the wording of the summons indicated that compliance had been required by 9th of March 2013, but actually Court in Roth went further. It also commented that the statement of facts which accompanied the summons clearly referred to the entire period of non-compliance. So the defendant, and this also is crucial, the defendant knew the case he had to meet. Well, you could have said that about Panayi as well, but anyway, in Roth, the Court of Appeal, different constitution as the Court of Appeal, of course, made these comments and said that. And the judgment continued. Even if there were technical deficiencies in the drafting of the summons, they are not fatal. And what we mean here, of course, is they are not fatal to the confiscation. They are not fatal to the finding that the benefit of the offence continued over a longer period of time. The judgment also did say that the use of phrases in a summons such as on and since a specified date, of course, we didn't see that in either of those summons, but something like on and since could have worked better, or between one date and a later date would have been preferable. And of course, that's often what we see in criminal summons, don't we? Between this date and that date, some criminality occurred. So in effect, what they're saying in Roth is wasn't very clever to refer to a single day in the summons. It would have been better to say either on and since or between this date and that date. Now, just last month, there has been another case, the case of the London Borough of Barnet and Kamyab, and again, the reference is there. That was decided on the 15th of April, 2021. This is an interesting case as well, because here a confiscation order had been made for £270 in the Crown Court. And the judge made that on the basis that he was bound by Panayi. So it was based on a single day. The prosecution appealed under section 31, subsection 1 of POCA. As you will know, under section 31, the prosecution can appeal against a confiscation order that is made in too small an amount. Also under section 31, subsection 2, they can appeal where a confiscation order is not made where they feel it should have been. So the prosecution, unusually on sentencing, has rights of appeal against a confiscation order which is made in too small an amount under subsection 1 or not made at all, in which case they appeal under subsection 2. Now, I mentioned, didn't I, that this order had been made by the judge on a preliminary point. He was asked to decide first, is this a case in which the benefit should only be related to one day, in which case the benefit is going to be £270, or is it a case in which the benefit is not limited to one day, in which case all sorts of other issues arise? And he said, no, it's one day, thank you and goodbye. So the appeal succeeded. There was an appeal, the appeal succeeded, and the court has said some interesting things on the appeal. They went rather further than they had gone in the case of Roth. One of the interesting things that they said was this: generally, and I'm quoting from the judgment, generally in indictments or summonses in criminal cases, dates are treated as not being a material averment. So it's not exactly saying dates don't matter, but dates are not crucial to the offence that's being dealt with by the court. And they said the offence under section 179 is a continuing offence. And the defendant here knew exactly what was alleged. So they said, with regard to convictions for breach of an enforcement notice, they said this: whereas here, the nature of the offence, and we're talking about the statute, the nature of the offence created by the statute is that it is a single offence which is committed throughout a period of non-compliance. We would suggest that it would require very clear words in the summons and in the presentation of the case to limit it to a particular day. So in fact, they've pretty much, it seems to me, kicked Panayi into touch in the sense that not only has the summons got to be badly drafted, but the presentation of the case has got to be badly done, so that the defendant wouldn't recognize, or perhaps wouldn't recognize, that what was alleged here was a continuing non-compliance and not simply a non-compliance on a particular day. That, I think, will be a relief to an awful lot of local authorities. They also made a point about taking preliminary points in the Crown Court. And again, I'm very largely paraphrasing here, but in essence, what they said is don't do it. Now, as a forensic accountant, looking at confiscations, I sometimes see a confiscation where there's a section 16 statement and a lot of detail about the assumptions and how they've been applied and what the benefit is. And I look at the case and I think, hang on a minute, this guy does not have a criminal lifestyle. So scrub the assumptions, they're not applicable, it's not one of those cases. And from my point of view, I would like I can see an attraction in going to court and saying to the judge, look, judge, can you just give us a decision as to whether or not criminal lifestyle applies? Because if it doesn't apply, I don't have to bother looking at all this assumed benefit that's in the Section 16 statement, which is going to take me ages to work through. And I suspect that at the end, it's going to prove to be a complete waste of my time and the legal aid agency's money, because it's not a criminal lifestyle case. So from my point of view, yeah, I'd love to take a preliminary point to court, have that decision made, and not have to bother with looking at all the assumed benefit, going through all the bank statements, going through assets held after the date of conviction, going through expenditure since the relevant day, going through all these things. I'd love to not bother with all of that and just get straight to it. But the Court of Appeal here is saying, do not do that. What you have to do, in effect, what it means to me is what I have to do is, even where I think it's not a criminal lifestyle case, I still have to go on and address all those assumed benefits, look at the bank statement, look at the expenditure, look at the assets held after the date of conviction, where they're assumed benefit, and deal with all of those before it comes to trial. Well, why? Well, here's the reason. The judge in the Crown Court, in this case of Kamyab, made a decision on a preliminary point, made the decision that the benefit was limited to 1 day's rent of £270, and did not go on to make any factual findings about what the benefit would have been if it's not limited to 1 day. So when it got to the Court of Appeal and the Court of Appeal decided that was wrong, what could they do? Well, those of you who do a fair bit of confiscation will know that the Court of Appeal has power to remit cases back to the Crown Court where an appeal is successful. But that power is limited to the circumstances in which the court has not made a confiscation order at all, and the Court of Appeal decides it should have made a confiscation order. This case of Kamyab was not one of those cases. The court had made a confiscation order. The appeal was under subsection 1 of section 31, not subsection 2, which deals where there's no confiscation order. And under subsection 1, the Court of Appeal does not have power to remit the case to the Crown Court for reconsideration. So what could they do? Well, unfortunately, the Court of Appeal now, because there are no findings of fact from the Crown Court which it can use, the Court of Appeal now has to reconvene in the summer and hear evidence over 3 days on the facts. They were not amused, as you can imagine, because the Court of Appeal really isn't a fact-finding venue, is it? It's not intended for that. And unfortunately, the Court of Appeal have actually got to properly hear the case over 3 days in the summer to decide what this gentleman's benefit actually was, and to make an appropriate confiscation order. So they didn't exactly tick off the Crown Court judge, but they did obviously feel that it was most unfortunate that he'd taken this as a preliminary point and not gone on to address the issue and address the facts and make findings of fact, which they could have then used, had they been there, they could have then used them to make an amended confiscation order. Okay, so hopefully we will not see problems in future from the wording of summonses in enforcement notice cases. Hopefully all these sort of issues will be avoided by getting the summons right, and by getting the decision in the Crown Court right, and these won't be the subject of appeal. So Rounding up, Bartfield's Forensic Accountants, as I'm sure you know by now, remains fully staffed. We're getting back in the office. We're undertaking legal aid work, privately funded work, criminal work, civil work. And it is relatively easy for us to conduct the bulk of our work remotely. We're meeting in the office more than we were about 6 months ago. We're still working remotely as well. We are readily contactable by phone, by email, online. And our recently updated website is full of useful information and, of course, accessible 24/7. You can find more on this topic on our website. And this and previous webinars can be found in the seminars section of the website. The links are there on the screen. A free recording will be emailed to you, free recording of this webinar, and my email address is on the screen now. If you have any queries, you need any help, do drop me a line. By email is best because it's very difficult to deal with these sort of queries off the cuff on the phone, and I'm not always in the office even these days. So drop me an email and I will get back to you as soon as I can. Thank you again for your time. I hope this has been useful, and we will see you again in a fortnight. Bye for now.